So we have another couple of minutes to go.
Sure.
Thereafter, we will start. I'll just give you a hint, Mridul. Then you can start. By the time we will have few more persons joining us.
All the best, Mridul. Take care.
Andrew, the attendance every day is around 150. We slowly reach there.
Unmute, unmute. Unmute. Sundar,
Yes.
unmute.
Yes. I, in fact, advised Mridul, electricity cut is there. So there is a problem at her place. So I advised her to come on mobile so that she can continue with the program. Have you come back, Mridul? Probably not yet.
Not yet.
Just check. I told her to join. She said, Mridul, are you there?
I, in fact, advised her to come on, to come through mobile.
I had told her, sir, but she said it's not, Zoom is not there. But she said, yes, ho gaya. And where is she? God knows.
In a minute or two, we'll start. Mridul is here. Now you can start, Mridul. You have to unmute.
She said,
Unmute.
yeah, I'm not getting connected.
Unmute.
Good.
Now you can start.
Namaste. This is Nivaran, mediators of Supreme Court of India in collaboration with CLA, Commonwealth Lawyers Association, and SIMC, Singapore International Mediation Center, presenting 5th International Virtual Mediation Summer School 2024. Greetings from India to all the participants joining from all over the world. I am Ridul Agarwal, an advocate and mediator at Supreme Court of India, your host for today. I am a mediator with Delhi Dispute Resolution Society at Delhi also. Namaskar. This is a 10-day education on mediation. Today is the 7th day. On the day of inauguration, we had, among other dignitaries, Mr. George Lim, President SIMC, Singapore International Mediation Center. In his inaugural address, he has testified the growth of mediation over the globe. Despite the fact mediation does not have any New York Convention as arbitration has. He said mediation is humanizing legal process. Mr. Jawad, expert on mediation from India while teaching the age-old concept of mediation, has said that it is a sin to call mediation as ADR, alternate dispute resolution. Litigation is alternate to mediation. When mediation fails, one goes for litigation. For mediation, most important aspect is an unhindered communication by the parties and with the parties. Today's topic is communication. Interpersonal communication skills needed for a mediator, the path to understanding with verbal and non-verbal communication. Communication is the process of expressing by one and comprehending by other. Now, expressing by words, either orally or by writing, is known as verbal communication, whereas expressing through facial expressions and body language, like gestures, actions, etc., is non-verbal communication. What we are is the sum total of our influence on others. The mediator's way of making the parties influenced and comfortable is primarily non-verbal communication, like how he or she greets the parties in the mediation room, how absorbing he looks while listening to their stories. Today we have Professor Andrew Goodman from London. This is one of the most fascinating resumes I have ever come across. Professor Andrew is a barrister since 1978, conferred Master of Bench Inner Temple in 2009, has been an accredited CEDR mediator since 1993, practicing in commercial, construction, development, partnership, franchising, professional negligence, workplace, higher education, and family business disputes, helping parties resolve more than 400 claims till millions of dollars in United Kingdom, UAE, Hong Kong, Egypt, Kuwait, Switzerland, Netherlands, Singapore, we name the place and it's here. He was recommended as a leading junior in professional indemnity claims and as a leading mediator in the Legal 500 for over 25 years and for 4 years by Chambers Directory. Since 2005, he is member of the England and Wales Bar's ADR panel. He is a distinguished fellow of the International Academy of Mediators and is acknowledged as one of the world's leading specialist mediation and advocacy trainers. Working with Bar Council, RICS, ICAEW, HMRC, the International Advocacy Training Council, FIRS Nigeria, and in many more jurisdictions. He was an itinerant visiting lecturer on the LLM and MA dispute resolution courses at UCL London and a peripatetic lecturer at other UK universities. He is a visiting professor at the School of ADR, Faculty of Law, Department of Human Development, National Open University of Nigeria. Sir has provided training in mediation at the ICC, Paris, Hong Kong, Delhi, Bangkok, and so many other places. He also regularly lectures on international contract management to oil and gas, construction, procurement, and service industry managers throughout MENA, the GCC, and Southeast Asia with a view to conflict prevention. Professor Andrew is the author of over 50 books, including Effective Mediation Advocacy. Fourth edition is available of 2024. Advanced Mediation Advocacy 2024. How Judges Decide Cases and Effective Written Advocacy in Practice are among few books written by Sir. Sir advises governments, judiciaries, and private companies on dispute management and prevention system. He has a website, www.mediationconsulting.co.uk. So friends, we have a highly professional educationist speaker today. Over to you, Professor Andrew Goodman.
Thank you very much indeed. Namaste and welcome to colleagues, not just in India, but from around the globe. It's my very great pleasure to return to your annual summer school. I very much enjoyed participating last year. And this year, I need to thank you in particular for the indulgence of allowing me to come fairly late to the program. I've been working this week in Dubrovnik in Croatia. And I want to start talking about interpersonal communications in the form of the mediator's skills by reference to, I think, elements which, for those of you who are already established mediators, will be very familiar. However, for those of you who are less familiar and who are either students or practitioners who have yet to engage in any substantial way with the process of mediation, I thought it might be quite useful to go back to basics with regard to what I have to say. But there are a number of caveats. The first caveat is that it probably would have been more useful to have had this talk at the beginning of the week rather than the end of the week, but I'm afraid that's the way things played out in my diary. Secondly, what I have to say is really based on my own experience and my own knowledge gained from different jurisdictions. And I make no bones about it. It's entirely my personal opinion, and you are free to disagree with it, particularly when I lay stress on various emphases which you may think are less important. I think also, in fairness to the number of people who are online at the moment from different places, I want to talk as generically as possible. There is no point trying to confine what I have to say to any particular jurisdiction, although I recognize that for many of you, mediation sits in a cultural hinterland, which, funnily enough, is not shared by my own jurisdiction. So far as England and Wales is concerned, mediation arrived in the form of a franchise, which was bought from an American company in April 1989. And we simply had no hinterland to reach back in the same way that I know my friends in India and my friends and colleagues in Nepal have. I'm familiar with the concept, the ancient concept of finding and using a pancha to provide wisdom to people who fall into dispute. I don't hold myself out to be a wise man, But I think the first attribute of a mediator in advancing interpersonal skills, interpersonal communication, is realism. I think you have to be realistic, and I think you have to be pragmatic. So let me start by setting out the scene. I think that too much emphasis is placed on standardization in the use of mediators' particular skills. It's perfectly true that entry-level training for mediators is designed to try and create a minimum standard and the minimum usage of interpersonal communication skills. And I'll refer to these basic 5 principles in a moment. But for me, the key aspect of the work of a mediator is an expression of that mediator's own personality. I think the mediator has got to imbue into his work or her work their own personality. And that means that they can, depending on the case in front of them, they can be directive, they can be managerial, they can be controlling, but they can also exhibit a light touch in circumstances that warrant it, where you are simply trying to push the parties in a comfortable way, where they themselves can understand what is necessary to come into being for them to arrive at a settlement of their dispute. So I've really been thinking about this in the course of trying to guide parties on a path of awareness to enlightenment. And I think really this is the core role of the mediator in using interpersonal communication skills. And I want to start off simply by looking at what I consider to be the universe in which the mediator is operating. So I want to, yes, I think I've blurred my background. So I want to find a way of unblurring my background. Sorry about the mess. But I'm afraid, because I'm a natural trainer, I would much prefer to use a flip chart than slides. In the course of both my work and my training, I tend to use 2 different types of methods to convey the information that I want. And in this instance, I'm interested in making use of a Venn diagram. And the Venn diagram shows the position of the mediator at the outset of the mediation. We have, let's say, for this example, 2 parties. And the parties the parties populate the entire universe of the problem that the mediator faces. And the mediator is contained within this ellipse in the middle of the Venn diagram. And I tell my students when I talk to them that what the mediator is trying to achieve is an expansion of the ellipse, so that as the mediator grows in knowledge, understanding, and confidence, the ellipse will get bigger and will try and subsume all of the issues between the parties, which represents the contentions between them. And this is the entire universe of knowledge that is required in order to make the process work. What the mediator starts off in a very narrow, thin sphere of this ellipse, because the mediator's knowledge is limited at the outset. The mediator uses interpersonal communication to gain knowledge through the entirety of the process. Now, there's another way of interpreting the same aspect of this Venn diagram, and that's why I find it a very useful tool. Not only is this the knowledge of the parties and the knowledge of the mediator, but in a sense, it also represents understanding. So here is party A's understanding. And when the mediator comes to deal with party A, so the mediator will enhance and grow his understanding of party A's starting position. But as he looks at this, and the mediators will be perfectly well aware of this, what he's looking to understand, or the path to understanding, is concerned with the party's interests. By the same token, the mediator engages with party B and undertakes the same exercise. He wishes to understand both his knowledge, but more particularly his understanding. And the way the Venn diagram operates is, as the ellipse is expanded, so the commonality between the parties becomes greater and more prolific and understood by everybody in the room. So by way of just a very simple example, we know that the starting point is that party A will have interests, party B will have interests. You'll have to excuse my writing, I moonlight as a doctor. But of course, in the middle, they have joint interests. And as the process goes forward, those joint interests become more apparent, they become more understood, and the wider the ellipse moves, the more the joint interests identify and reveal options for mutual gain. I put here OMG, options for mutual gain, based on joint interests. Now, the mediator recognizes as a generic principle that those interests are underlying interests. They are there all the time. And if we take a generic approach, joint interests or mutual interests include the obvious need to solve the problem. That is, obtain an outcome which is agreeable to both parties. So both parties have an interest in being satisfied with the outcome. Both parties have an interest in stopping the dispute. Why? Because it costs time and it costs money and it costs aggravation and stress, and it damages opportunities, it damages relationships, it leads to a divisiveness which cannot be healed unless the parties both recognize that the need for healing. So this is my approach when I'm trying to prepare a mediation. And the way I use interpersonal skills is no different. My communication with the parties, and indeed the participants, is no different on a generic basis. What I'm seeking is equilibrium or balance between the parties. And that means that I have to approach each dispute on the basis that there is no balance at the outset. So let me try and explain that. Each party is aware of its own position, but is not necessarily aware of the other party's position. Why? Because the opposite party is not within the concern or consciousness of the first party. They have no real interest in ensuring that the other party is satisfied with the outcome. And it's the communication skills that you need to move people from not just an awareness of their position, but to an awareness of the other party's position. Once we have this concept of awareness, the target is to have the parties understand that they can only succeed in getting what they need by having an enlightened approach to what the other party needs. My acronym is Options for Mutual Gain. Options for Mutual Gain. Because there is no point in each side making an attempt to bargain with something that they already know the other side will not accept. And if the mediator is acting as the diplomatic agent of a party, the mediator will already have sufficient knowledge as the ellipse expands to realize that there is no point in one party making an approach to the other side in respect of something the other side will find unacceptable. So we move from awareness to enlightenment, and we use the mechanism of these various skills that I want to list out now. The first thing I think the mediator needs to do is to recognize the importance of suspending judgment. And this is as much a skill as anything else. It's actually a discipline, because most of us approach the subject matter of the dispute having innate skills that we already possess as professional people. So either as lawyers or as other professional people, we are trained in critical analysis, problem solving, and communication. That is at the heart of what we do as professionals, to a greater or lesser extent, depending on the application of those skills to the work at hand. What this means is that we approach a mediation and the contents with a critical faculty. That there is no point in suggesting otherwise. The mediator is evaluating all the time. And the mediator has to do that, because the mediator is both applying his assessment to each party throughout the process, but he is also trying to multitask a variety of things that the mediator is called upon to do. But the very first thing you have to do is suspend judgment, because you cannot get to equilibrium or balance by assuming that one party is right and the other party is wrong. That is not the venue in which you're working. That's not the universe that you're populating. As a mediator, you have no interest in who is right or who is wrong. The parties will be using that as leverage to get the best deal possible. But you know that the only successful outcome is a deal which is going to be acceptable to both sides, and you need to understand what that is going to be. So the other important precursor to the mediation day is trying to envisage, if you're not looking at who's right and who's wrong, where the settlement is likely to emerge from. And either it's going to emerge from the dispute itself, or it's going to emerge from somewhere else. But we know, again, coming back to my diagram, that it's either going to emerge from the expanded knowledge and understanding, or it's going to emerge somewhere from these fields of knowledge. It's unlikely to emerge from anywhere else. So what are the skills that we are applying? So firstly, the most important skill of all, so far as mediators are concerned, is the skill of listening. All mediators are taught the discipline of listening in a particular way. And it's a process which everybody, I assume, on the call knows, is called active listening. And there is a lot of there is a lot of academic writing concerning concerning this concept of active listening, and it is recognized by practitioners that it is a very separate and distinct discipline, and it is at the heart of what it is that the mediator does. The other thing is that the movement from this sense of equilibrium or balance has got to be done on a fairly slow basis. You can't rush to settlement. It's quite likely if you rush to settlement, the settlement will either not be workable, or if you happen to be lucky, it's unlikely to be durable. And you cannot get there without the essence of acceptance and the essence of agreement, because you're trying to promote harmony amongst parties who have been disharmonious, generally speaking, for a very long time. You're guiding the parties through the use of listening, questioning, summarizing and reframing, delivering option generation, and projecting empathy. And of course, there is an interplay with the use of all of these skills. The extent to which you do that is a matter of control. One of the things you need to do is to get people to talk. You have to get people to talk to you, and you have to get people to talk to each other. Getting people to talk to you is a social skill, and it is a question of both getting people to open up and also allowing people time to speak. And the process is a process of validation. So as you allow somebody to speak, the impact of your listening will create this rapport between you and that person who started the day as strangers and who may very well end the day as intimates on the basis of what they have revealed to you about themselves, their business, their family, their social arrangements, their wider interests, their culture, their background, their history. And this is information that you, the mediator, will receive and store and evaluate, and analyze, and you will regurgitate it when you summarize and reframe. I think that it is possible to reduce this even to fairly simple patterns. I say patterns because they are simple, but they're not necessarily simplistic. Example: a question, listen, express understanding, summarize. Question, listen, reframe, summarize. Question, listen, summarize, offer empathy. Question, listen, challenge, reframe. Summarize, question, listen, reframe. We're moving always from the destructive to the constructive, and we're moving always from the negative to the positive. So let me try and break down these core interpersonal communication skills. What is it that we're listening for? It's all very well to talk about you have to discipline yourself to listen hard, to show that you're listening, to exhibit the fact that you have listened by summarizing, by asking more questions, by offering empathy. And you develop a technique where, on the one hand, you're creating this pattern that I've suggested. On the other hand, you're trying to evaluate and pick out from what you're being told the matters that are clearly important to that particular party. What you are doing is matching that party's story, that party's desires, that party's wishes. You're picking out of that what is likely to be a preformed agenda. When you prepare for the mediation, you need to recognize that everybody in the room, party or participant, will have their own agenda, will have their own reason for being there, which is driving them. The lawyers will be there to earn their fee, but also to develop their reputation and to come away with a settlement for their client, which makes the client happy and which makes the client recommend the lawyer. It's a nice business case. It's a simple business case. It may be that the lawyer is interested in looking at the lawyer on the other side. And it may be that the parties who come with an agenda walk away with an outcome that they never expected when they arrived. And therefore, one of the communication skills is to be able to discuss option generation at the right time. But of course, you cannot begin to discuss option generation until you have a complete understanding of each party's interests and concerns, and to elicit from them the core matters of importance. Because it may be that, firstly, that only emerges in the course of conversation, because what they thought was important, what their lawyers may have told them was important, is in fact not the key driver which is keeping them locked into the dispute. It may be that it emerges with awareness and understanding. Secondly, the parties come together at a time when they have been kept separate from the dispute. And therefore, one of the vehicles that the mediator uses is to get the parties to talk together. The mediator has to decide whether or not that's going to be a good idea, how to manage it, and the extent to which the mediator needs to keep control. I was mediating the week before last in a dispute where the parties simply hadn't spoken to each other for a very long time. They'd spoken about each other, they'd spoken with their lawyers, and they'd formed an impression about the other side, which needed to be diffused and then needed to be removed. And the only way that I thought that you could do that was to simply have them sit there and talk. And it emerged in the course of the conversation, firstly, that they wished they'd been able to talk to each other months and months earlier. Secondly, they developed an understanding of what the other side felt was important. They cleared away misconceptions, and they understood that in order to move forward, they had to accept some of each other's viewpoints. Now, the mediator is either doing this in the course of a diplomatic intervention, where the mediator passes from room to room, from party to party, and clarifies this. But in many cases, it's perfectly possible for the mediator to simply be present and allow the parties to make these various discoveries by themselves. The point that emerges is once you get to understanding, then the parties have learnt how the dispute has come about and themselves how to solve it. In First Nation communities in North America and Canada, they have a tradition, they have a concern for an outsider coming in and telling them what to do. They call this the thief of learning, because it deprives them of an opportunity of learning for themselves what it is that they need in order to move forward. And I think that there's a lot of merit in this. It's perfectly fine for a Western-oriented mediator, commercial mediator, to come and deal with a business dispute where it is fairly clear that the option for mutual gain will emerge from the business process or the business relationship or tweaking the contractual relationship between the parties. But in cases that are not like that, in cases which are much more concerned with personal relationships, the mediator is using interpersonal communication to guide the parties so that they arrive at their understanding, so that the settlement arrives from their undertaking. And the mediator then can frame the dispute as a problem to be solved and not a case to be fought. And the mediator can then reframe the problem as an opportunity to re-establish their relationship where appropriate, and to understand the constraints that each have in the way that future relationship is to be developed. So I take this opportunity to simply lay out these ideas, simple but not simplistic, based on fairly straightforward and generic understanding of what it is that the mediator is doing or trying to do when he or she listens, the adroit use of questioning without putting people under pressure, but challenging where appropriate, using summarizing all the time, because our great strength is in our linguistic skills. We use language as a tool. And it doesn't matter whether we are using the language of the client rather than the language of the law or the language of the lawyer. Make the client comfortable and get the client to speak. Summarize, strip out the negativity, reframe, challenge where necessary, and help the parties to get to the point of understanding, from where you can move into helping them with options for mutual gain. So I'm told that I was limited to 30 minutes speaking initially, and it emerges that my 30 minutes has already lapsed. I'm very happy now to embark on questions, and I do hope that's been of some use to you. Thank you very much.
Are you there, Mridul?
Sorry, sir, I was not on. I was unmuted. Sir, thank you so much, sir. But there are questions coming up on the my mobile also. Yes, chat box and mobile also. The question that arises that when the communication is so important for the parties to embark on, so don't we? Do you think that we should start the lessons of communication at the school level?
I think that I think that most mediators arrive with the confidence of being more sophisticated than the parties they're dealing with. And although that sounds pretentious, I think that our professional background teaches us that, you know, we are used to articulating, and we are used to verbalizing, and we are used to uh, fairly sophisticated communication. And I think that the most important thing is to make the parties comfortable with the way we speak to them. We should not be patronizing. We should engage in speaking to people in the way that best suits them and enables them to understand. The very first thing that you should strip out is the language of lawyers. You should move into their world and talk to them about the things that are important to them. I actually generally start, and I'm sure that most mediators do this. If you want to engage with people who are in conflict, and therefore who arrive at the mediation probably in an emotionally heightened state, the last thing you want to do is to start talking to them about the conflict. You want to start talking to them about them and their family or their background or their business. Because the very first thing that you've got to do is create rapport. And you can't create rapport unless you get somebody to like you. You can do your work through respect. There's no question of that. But if you get them to like you because you can speak to them on a personal level about them themselves and listen to them in a way which encourages them to speak to you completely openly, with confidence, with discretion, in a confidential way, you're going to make progress pretty quickly. And it doesn't matter. I mean, obviously, we always have a standpoint in the UK because we can talk about the weather. It doesn't matter what the subject matter is, but do not start by talking about the conflict. Start by talking about something else and ease them in gently once you have an understanding of their world, because that's the world in which you need to move in order to find the answer to the problem.
Thank you. There's a question by Suvarna. How do you start mediation with parties who are dismissive of the mediation process?
Okay. I think the best thing to do to sell the mediation process is to simply say to them, look, I appreciate this is an alien process. It's not something you understand. But let me ask you a question. And the question is, if we can solve this dispute today, after all this time, what are you going to do tomorrow? What is this going to mean to you? And already you're going to engage them in thinking about, we can solve the dispute. What am I going to do when when I haven't got this in my life anymore? How am I going to replace it? Let them think about that rather than worry about the dispute and worry about the mediation process itself. And make the process a side matter. It doesn't matter what you do, quite frankly. I had parties the week before last who said to me, we don't understand what you did. And I said to them, I didn't do anything. You did it yourselves. And therefore, don't let them worry about process. Don't spend a lot of time talking about process. They're not really interested in process. What they're interested in is outcome. They're interested in finding a way to solve this problem so that they can walk away and live the rest of their lives and get on with it. So please don't worry too much about that.
Thank you so much. There is a question by Swati. Good evening, Andrew. With the increased usage of tech, we are able to easily communicate virtually, but interpersonal stimulations like a handshake, voice as a form of touch are not present. Do you think physical interaction between parties will have more impact when compared to virtual mediation?
Yes, I do. And there's no question. I do both. They both work, but you need to understand that a virtual mediation is different. It's different for a number of reasons. Firstly, you can't see, generally speaking, you cannot see the whole body of the people that you're talking to. You can see head and shoulders, and if you're lucky, a bit of torso. And even when you introduced my talk, you were speaking about non-verbal communication and body language. And it is actually much harder to evaluate on screen what's happening by reference to the whole of body language. It isn't simply a question of reaction in the face or in the eyes or in the mouth muscles. Body language includes the way people are sitting, so it includes posture, it includes movement, and these are lost on the mediator by and large through no fault of his or her. The advantage of technology is, of course, it's more convenient, it's cheaper, people don't have to travel, there's no accommodation cost, and it's a matter of balance. And I think that if you are advising people about the choice, you need to make them aware that it is not the same. I do personally much prefer having people live in the room. I think it is important to be able to take into account on a holistic basis everything that it appears in front of you. And I think reaction is very important. And I think that reaction can be disguised somewhat when people are on screen. It also means, of course, that the mediator has less control because the parties may be doing something else unknown to you. They may not have their full focus or their full attention on what they're doing. And it may be that there are distractions where they are, and the mediator can't control that. The mediator may be concerned that there are actually other people in the room sitting behind a party's camera who can't be seen and who are influencing the outcome. And I had that. I could tell by a party's eyes that he was looking at somebody else rather than me. And in the end, I said, look, it's fairly obvious there's somebody else there. You need to tell me who they are and let me see them. And then I had to get them to sign a confidentiality clause in the mediation agreement. So that's a bit of a problem. I do think that in terms of personal communication, live is far more important than virtual or online. But that doesn't mean you shouldn't go for online in circumstances where parties say, look, we can't afford to travel, we cannot afford to pay for additional costs because of accommodation. And I think that a mediator should weigh that heavily in deciding what the most appropriate forum or method is going to be.
Yes, thank you so much, Andrew. There's another question by Amitesh Rath. How does one mediate between parties who do not get along with each other? Of course, Amitesh, not getting along, that is why they have dispute. How does mediation between highly contested points take place? How to balance the expectations of both parties?
Okay, so I think this is one of my favorite subjects because, as you know, we start from a position of neutrality. And we have to maintain neutrality right the way through the process. And where you've got parties who are so at odds with each other that they won't come into the same room, they won't speak, it's going to be a problem. And I think, and I'm afraid what I'm going to say is quite controversial. I think you need to leave neutrality behind. I think you have to persuade people that for the time that you are with them, you are part of their team. And that when you are with the other side, they don't need to worry about it because you're going to be part of the other party's team. So what I'm suggesting is that instead of being neutral, where you have particularly difficult clients who refuse to see the other side's point of view, the mediator becomes bi-partial rather than neutral. So you can be neutral for the purpose of making sure there is no conflict, and you can be neutral for the purpose of making sure there's no prior association. But when it actually comes to the day, to the event, what you're selling to each party is the opportunity to walk away from the dispute with an outcome that is something of benefit to them and which is something they don't have at the moment. And it doesn't matter how angry or upset each party is with the other. That's what you're selling in both rooms. Now, okay, I'm being asked to explain bipartial as a concept. If I'm in party A's room, then party A is paying me to get a deal for him, correct? But when I go into party B's room, party B is paying me to get a deal for him. So why is it that I can't be a friend to party A when I'm with party A and a friend to party B when I'm with party B, and use the rapport that I build in both rooms to enable them to formulate an outcome which is acceptable? I don't have to do my job any differently by calling myself neutral and by asserting neutrality. The only thing that I have to be very careful of is to make sure that I comply with the rules of confidentiality so that I don't breach the trust of either party in the opposite room. But that is what I mean by bipartial. And I don't think that's a difficult question. Can bipartiality work in court-directed matters? I mean, my initial reaction is it doesn't matter if it's court-directed. You leave the court behind. When the court is directing you into mediation, the door of the court is shut and the door of the mediation room is open, and they are different venues and they are different environments. And what happens in the mediation room has got nothing to do with the court, to the extent that I'm not even prepared to tell the court what the settlement is. It's enough for the court to know that there is a settlement which both parties are satisfied with. Sorry, that was an aside to that question. If you are acting bipartially, if you are acting in favor of each side in each room, then they will trust you at a point when you say, I think it's worth sitting down with the other side now. Because they know that you will defend their interests. And in each room, you will be respected as the person who is literally holding the ring. But if you can say to them, now is the time when you need to listen to what the other side are saying. And now is the time when you need to tell the other side what you think is important for them to know. And this, of course, is the point which I would generally, as a mediator, at entry level, we're trained to have an open session at the beginning where everybody comes together. Because what we're doing is we're saying to somebody, look, this is your opportunity to say what you feel, what you think, what has happened, how it's affected you to the other side at a time when they cannot interrupt and they have to listen. And you can say it in your words, not the words of a lawyer, in your words. And let them see how what they have done has affected you. And let them see how upset you are and how aggrieved you are, because they may not know. And you want to say that this is such a valuable opportunity. Without it, unless it's a purely commercial dispute and you're dealing with organizations full of amorphous people, unless it's one of those, I cannot see how the parties can get to true catharsis and allow themselves the luxury of drawing a line under what has happened and being able to move on with their lives. I really do think it's incredibly important. And I also know that in many jurisdictions, we are hearing people who say, I don't want to have a joint meeting anymore. We don't think it's necessary. We don't think it helps in making the deal. We think it's disruptive. We think it takes time. And I think they couldn't be more wrong. I'm afraid I feel strongly about that. It's my view. I think in every circumstance where you think benefit will be derived to either one party or another, a managed, controlled joint meeting is vital. And it doesn't matter whether they shout at each other or scream at each other or curse each other. The mediator can jump in and say, that's enough. I want you to listen, because it's fairly obvious that this is an emotional thing, and you need to understand why people are being driven emotionally. And you need to listen to the other side to hear what's happened to them as a result of what they say the dispute has caused. And it's only after you've heard that you can get to a full appreciation of what is necessary in order for you both to be able to move on. And that is the way I practice, and that is my strong view.
Thank you, sir. Now there is another question saying, how should we move when parties get stuck during mediation and an impasse is created? It's being asked by Mr. Sumesh.
I think mediators have 3 or 4 fairly standard techniques to try and bridge gaps or break deadlock. The first, of course, is that the mediator needs the freedom to decide whether or not to tell the parties they are in deadlock. And I think that in fairness, the mediator has to explain to both sides that there is a deadlock. Now, normally a deadlock occurs because the parties have come to the mediation with an expectation, and the expectation is supported by authority to settle. And it may be that the authority to settle is limited, or that the party's expectation tells them thus far and no further. And mediators start by looking to, I mean, they see the difficulty without understanding the methodology by which the difficulty can be overcome. One of the first things that a mediator can do is to retrace the steps of the party, because you will obviously or most likely have a step-based process in which, once you get to the negotiation phase, the mediator is carrying offers backwards and forwards across the different rooms. But what has happened is that the parties between themselves have created a path, and the path is, as the mediator is sort of inching the parties along this path, where the parties are at each end of the path. I suppose this is the best allegory, and they're gradually taking steps toward each other. And they come to a point where they're not proceed to move any further along that path. Let us imagine that the deadlock is represented by a bridge, and neither party is prepared to cross the bridge. The first thing that mediator can think about by reference to this allegory is that the parties are not confined to that path. There may be another path, and there may be a different bridge. And what that means is the parties have yet to understand and expand this part of the ellipse, which is concerned with options for mutual gain. So what I would like to do is, I suppose, ask the parties is there anything else that you would like which represents value, which sits on another path, a path we haven't gone down yet? Options for mutual gain are not confined to the payment of a sum of money. If all you're arguing about is money, then it may be that you can apply time to money. And under those circumstances, the amount is not the finite answer. It may be that the time over which payment is made or tranches of payment may help parties get across the particular bridge. But one of the, I mean, I work in many disputes which are related to the problems thrown up by COVID and the pandemic. And what I think is obvious is that the great failing of our court system, which produces a winner and a loser on the basis, for example, that a court is being asked to interpret and enforce a contract, and the remedies which are being provided by the law for breach of contract or failure to perform the obligations under the contract, where the court considers the obligations which were entered into by the parties as intended by them when the contract was concluded and came into being. The great failing of the court is that the court, certainly in my jurisdiction and most of the jurisdictions in which I practice, the court has no power to renegotiate the contract or assist the parties in doing so. But if you're going to reset a relationship, and it isn't simply a question of money, then one of the aspects of knowledge or understanding which the mediator needs as he expands the ellipse is to recognize that parties have certain desires and that the parties or ambitions, and those parties should be given free rein in order to give the set out as many ambitions as they have, as much as possible. I always ask parties to come to a mediation with a shopping list of everything they would like. And over the course of the mediation, we can classify it and we can prioritize it. And it may be, coming back to my allegory about coming to a bridge that you're not prepared to cross over. You can go back to the shopping list, find something that has been discarded, and then build it into the offer. If you're not prepared to accept this, is there anything else that we can add which would make this offer more palatable? And you can do it for both sides. So that's the first thing. Secondly, why is it a matter for the mediator? Why is it the mediator's problem that the parties are in deadlock? It's not my problem, it's the party's problem. They either want a settlement or they don't want a settlement. So the next ploy of the mediator is to use the technical terms, BATNA, WATNA. So you ask both parties, well, what's going to happen tomorrow when you haven't got to agreement? Explain to me what your best possible position is. How much more is this dispute going to cost? How much of it is going to be irrecoverable? How much longer is it going to take? How much more management time is going to be wasted? What is the opportunity cost to you and your business because you're spending time dealing with the case when you could have settled it today? And what do you say is going to be the ultimate outcome if you are going to continue to fight? What is the stress that's going to be caused to you? What is the stress caused to your family? And all of these questions are questions that the mediator can ask, because you are ramming home the fact that you have the opportunity to settle. This is what's going to happen if you don't settle. And then, of course, you go back to what I've said before. If you do settle, I mean, obviously at the moment you can't because you're not prepared to cross the bridge. But if we do find a way of getting you across the bridge, what's that going to mean to you? Because all the other stuff goes away. What value is there in all the other stuff going away? Is there sufficient value to enable you to walk at least halfway on the bridge? So that's the second technique that the mediator would use. The third technique commonly used by mediators is to bring the parties together into the same room and say, I'm afraid you are deadlocked, and it looks as if there's no further room on the road that you're currently on. So here is a whiteboard, here is a flip chart. Throw some ideas at me without being judgmental. Let's see if something can emerge from joint discussions rather than you being confined to your own rooms. And we will invite the parties to what I think is now called brainstorming in most places, but not in some others. So those are really the three basic techniques that I would use as a mediator. At least one of them should have some impact on at least one of the parties. If, on the other hand, it's somebody who's representing a company, corporation, or institution, and they simply haven't got authority to go any further in deal making, then that's a separate question to be addressed. And whatever time it takes, you're going to have to ask them to get more authority or to get the people who are making authority to allow them to explain what's happened and see what the position is going to be. But also encourage them to pass back the discussions and knowledge about the BATNA and the WATNA. Sorry, a lengthy answer to a question. Most of these questions are straightforward questions, but they're not that easy to answer.
Yes, a little. Thank you so much explaining so well. There's a question from Jamaica. This is C. Higgins saying that please expand on bipartial as a concept.
I'm not entirely sure that I can do much more than what I've said before, but I'm happy to summarize it. Bipartiality means that you recognize and accept the value of each side's position. And when I said that the mediator has got to be non-judgmental, you have got to depart from your normal standard of analysis. When a case comes to you as a lawyer, then your own experience will tell you whether it's likely to be a winning case or a losing case or a case which could go either way depending on the evidence. But when you're a mediator, there is absolutely no point in formulating that view. Firstly, because the mediation isn't about deciding the case. The mediation is about satisfying the interests of the parties in a way which means the case never has to be decided. The only reason that there is value in the case is that either one side or the other will try and use the benefit that they think they have as leverage in the negotiation. And the mediator is simply going to discount that. I'm reminded of something I heard in Singapore. And if there are any members of the Singapore mediation community on this call, they'll know what I mean. And we were having a discussion about mediator selection, how you choose the mediator. And the lawyers in Singapore would say to me, I don't care what kind of a mediator it is, as long as the mediator's on my side. And that sounds very funny, but that's at the heart of being bipartial rather than being strictly neutral. If I'm bipartial, I'm on that party's side. And when I go next door, I'm on that party's side. And I don't think I can put it any more simply than that.
That's true. Thank you so much. So one more question is there from Anil Bhatnagar ji. What if one of the party is having limited authority to agree for an amount of compensation?
Yes. Firstly, I think that the mediator needs to know that the authority is limited. But that does not mean the mediator wants to know what the limit is. If a party says to me, I have limited authority, I need to respect that. Look, it's very unlikely, isn't it, that people come to do a deal, that they are willing to do any deal. Unless somebody is in a particularly weak position, I wouldn't expect that to be their attitude. I would expect that the parties come with an expectation. They know the figure that they're minded to settle for, or that they have authority to settle for. And invariably, the course of the negotiation moves in a way which surprises them. And very speedily, they are standing on the trapdoor represented by the limit of their authority. And they are scared that they are going to fall through the trapdoor. And if they fall through the trapdoor, they don't know how far they're going to fall. So I respect that as mediator. But there comes a point where you have to examine the limit of authority. One of the things you want to know is whether you can disclose that limit to the other side and simply say, that's all that's available. And that's as far as we can go because that's all that's available. Then the other side, I think, have got to have time and space to examine the proposition for its veracity. And you, the mediator, have really got to form a view about what you're telling, whether what you're being told is true, or whether you are being used as a conduit to persuade the other side through your independence or through your neutrality that that is likely to be the last offer available that day. So the next question is to the party. Okay, so I understand we've now arrived at the limit of your authority. What are the prospects for getting more authority? How can it be done? And what time will that take? And then, of course, as a mediator, you're concerned that if somebody asks for more authority, then the people who are giving the authority simply won't have been influenced by the mechanisms, the dynamics of the mediation. They simply won't understand why somebody's ringing up and saying, I need more money. Now, I think it's perfectly possible to negotiate a deal which is going to be the subject of ratification. And that's where the parties themselves have got to take a leap of faith. Psychologically, there's a lot to be said for the concept of leap of faith in mediation, because it requires a party to make the opening offer. That of itself is a leap of faith. And it requires a party to understand the proportion of the existing offer with the available resources which represent the limit of authority. But there are many types of mediation where somebody is representing management, and they have to go back to senior management, or they have to go back to a finance director, or they have to go back to a board. That's not unusual. And therefore, I really wouldn't be scared about want of authority, and I certainly wouldn't want to be embarrassed about limited authority.
Thank you so much, sir, for your kind words. It was really informative and insightful. So we thank you, Professor Andrew, for your enlightenment to the mediators to use 5 specific skills of awareness to move lawyers representing parties along a pathway from contest to collaboration and creativity. So still we have a lot of questions left. I'll WhatsApp you. If you intend to answer, we'll post in our group. So you have been successful in bringing new thinking to the audience and a fresh look at a basic subject of communication in mediation. Thank you once again for sparing your precious time, sir. Thank you so much.
My great pleasure.
Thank you, Rahul and team, for the technical support. I, on behalf of Nivaran, thank all the participants individually. They are the peacemakers of tomorrow. Their active participation is highly appreciated. You all are invited for tomorrow's session also. Tomorrow is day 8. We will have on the dais Mr. Duncan Turner speaking on mediation advocacy. Our host would be Ms. Manjula Gupta. So finally, signing off, namaste.
Thank you, Andrew. Thank you very much.